I've reviewed the papers that have been filed, and it appears at this point that the segregated funds that Ms. Huska took that were supposed to be applied to the Peak Division, that those have already been, I think, all used on Peak Division liabilities or obligations, I should say. And look, it sounds to me like the only remaining issue is, Mr. Glasser, your clients are wanting proof that the defendants have complied with the obligation to notify third parties about the name change, that they're not to be using the Peak Division name, or I should say A plus credit name. Is that really what's at issue left? And the request for an award of attorney's fees. Is that what's left, Mr. Glasser?
Thank you, Judge. As to item number one, I do agree that the segregated funds have now been paid to the debtor to Peak Division. For item number two, I got back from a out-of-state vacation last week, but in my absence, the defendants gave us discovery responses, and part of those requests asked for the evidence of what they've done with third parties. I have not yet had a chance to review those, so potentially that information may be within those records. And Mr. Levitt could probably speak better to that. For item number three, yes, absolutely. We are looking for attorney's fees for forcing us to file these motions and repeatedly take up these issues with the court for relief that the court has already ordered. I'm happy to speak more on that or any of these topics if Your Honor wishes, but just letting you know my general input on those three items. Okay,
and the only basis for the request for attorney's fees, I believe, is ARS section 12349A3 for unreasonably expanding or delaying the proceeding. Is that correct?
That's correct, Your Honor.
Okay. So if there's any argument that you wish to make with respect to that, now would be the time. So go ahead, Mr. Glasser.
I appreciate that. Your Honor, this case is about a business that was taken apart from the inside. We allege that defendants took nearly $500,000 out of Peak Division. That's not disputed. They drained the accounts to zero. They did this knowing that Peak Division still owed money to its creditors, and they left those liabilities behind. That too is conceded. They then used that money that was never theirs, to fund the launch of a new business that competed directly with the company they had just emptied. They took client information with them. They took a name so close to my clients that customers cannot tell the two companies apart. That's not theoretical. My clients' customers have been confused in their own financial records about which company they're doing business with. And so when we came to this court for a temporary restraining order, we resolved these issues and the court entered its order. Two pieces of that order are relevant to today's hearing. The first is that the court directed that the designated funds, it's about $123,000, be applied to Peak Division's outstanding liabilities. And then the court also directed the defendants to notify third parties displaying the confusing name, which was A Plus Credit Info, to take all reasonable steps to get that corrected. That was December of 25. Since then, we've had to come back to this court again and again to get the defendants to do what the order already required. And each time compliance has come, it's come late, it's come under compulsion. Starting with the funds, recall we previously came to this court over $93,000 regarding a TransUnion invoice. This court then entered a specific directive to pay it by April 27th. Defendants delayed till April 30th, after the deadline that the court had ordered. We then, on April 14th, gave the defendants evidence of Experian liabilities totaling hundreds of thousands of dollars, well in excess of the amount of remaining segregated funds. We asked them to pay whatever remained of the segregated funds towards those liabilities. The defendants never once disputed that those are Peak Division liabilities, that they're subject to the order. They just didn't transfer the money. I followed up with them repeatedly through their counsel. I put this in the motion. We asked for payment by May 15th. None came. We followed up on May 18th, May 26th. Then eventually, and we told them we would do this, we filed a motion on May 28th. Finally, on June 16th, the deadline of their the deadline for their response to the motion, they finally sent out those funds. And even then, Your Honor, they were short by about $2,000 because, contrary to the court's December 25 order, they did not keep those funds segregated. About $2,000 apparently went out in some sort of auto payment from that account that had not been monitored. We also raised the A+ credit info issue. This is the issue with the confusing name. Specifically, my clients had gotten notice that someone asked them, "Hey, why are you charging me? I'm not even working with you anymore." But they were confused because the indication on the credit card bill said A+ credit info, and they thought that was my client. They're not. That's the confusing name that the defendants took. We asked repeatedly, Mr. Levitt, what's going on with that? Can you show us evidence that you've done something with this? The only time we've heard anything about that is in their filing. That's the first we heard that they had taken some steps to address this. They didn't respond to our motion to compel timely. We gave them an extension. They asked for more time. We did not agree. Then they filed even later than the deadline that they had asked for. In the meantime, we filed a notice of non-opposition under Arizona's rules. They didn't oppose the motion. They didn't ask for an extension. Or sorry, they didn't ask the court for an extension. They didn't get an agreed extension from us. They just filed it late. Their conduct, Your Honor, keeps forcing my clients to have to spend money for attorney's fees to address these issues to the court. There's no indication that they ever would have paid the remaining amounts from the segregated funds had we not filed our motions. Your Honor, they are costing my clients significant amounts of money, and bear in mind, they are now competitors with my clients. So sanctions are entirely appropriate in this case because they're entirely the result of the defendants not doing what this court has directed them to do. I'm happy to answer any questions Your Honor may have, and I'll save for a rebuttal if not.
Okay, thank you. Mr. Levitt?
Thank you, Your Honor. Like you said, there's two issues. The first is the money in the segregated funds. That has been taken care of. There was a delay in paying. My client attempted to pay the credit bureau directly for the bill, but the credit bureau was unable to take the payment because it wasn't coming from the Advantage Plus, which is the name on the account. So my client, once they realized that, wired the funds to the plaintiffs to get it paid, and it's been paid. There was a new bill that had come up. That was the IRS bill. And as we know, not all liabilities, Your Honor, are created equal. An IRS bill should be given precedent because of the possibility of personal liability that can flow from liability to the IRS. And when my client reviewed the IRS bill, we emailed opposing counsel, tried to get some clarification on what this bill even related to. There was no details whatsoever. He didn't have them either, and so my client paid the IRS bill directly before wiring the remaining funds to opposing counsel so that they could pay those amounts as they felt necessary. Yes, on January 6th, my client's, the segregated account had a $2,000 auto pay withdrawal that was set up to pay an invoice that was attached to that account. That was an inadvertent error, and we're grateful that opposing counsel brought it to our attention, and we rectified it as soon as it was. That auto pay occurred on January 6th, which was over a week before the court signed its order on January 14th. So sure, could we have done a little better job in making sure there were no auto pays attached? Yes, but we took care of the issue as soon as brought to our attention. Regarding the name, this has been, it's like, I don't know how to compare it, Your Honor, but it's like writing your name in wet cement. It's a lot easier to put your name in there than it is to get it out after it is, apparently. And there's two ways that this needs to be understood about the A+ name that my client had used. One is a customer-facing way, which is how do we represent ourselves to customers? What's the name we use? The other is on the back end way. What do some of these vendors and providers like MCL, which is Meridian Credit Link, which is an online platform that that our clients use, Fannie Mae, Freddie Mac, how are they registered in their system? My client changed its customer-facing name at the end of May 2025. And there's been no doubt that since then, it's been using this new name that it's been using that is not confusing for the last, I don't know, almost 17, 18 months. And so what we're talking about is the back end name. What is the name on the drop down of Meridian Credit Link or Fannie Mae? How is it registered there? That's what this is dealing with. And the credit card statement that was brought to their attention, which was then brought to our attention, deals with a back end issue. That credit card statement was for a client that does business, a customer of my client, of my client. And that customer was confused because their credit card statement said A+. Then they reached out to the plaintiff and saying, I don't do business with you anymore. Why are you charging me? And that's when it was understood that on the back end, on a credit card statement, it was listed as A+. The evidence in the case that we've put forward is that as early as October of 2025, we've informed the third-party vendors and platforms, MCL, Fannie Mae, whoever, to change that name. And the frustration that I think plaintiff and opposing counsel has with the delay in that change on the back end is with the third-party vendors, is with the MCL platform, is with Fannie Mae and Freddie Mac. It's not with my client. This court, in section 3 of the preliminary injunction, stated that my client should notify all third-party platforms, vendors, and systems to change the name of so that A+ credit info is no longer the displayed name on the back end. My client did that, and the evidence in this case is that my client did do that. This court further instructed that my client should take all reasonable steps necessary to ensure that those third-party listings and platforms and records, i.e. the back end issues, are updated. And that is something that we've done, but it's ultimately out of our hands. And we can't force Fannie Mae, we can't force MCL, we can't force a credit card vendor who has that name registered to change it. All we can do is what the court ordered us to do, which is to notify these third-party vendors, which we have done. Ultimately, we're here because they filed a motion to compel. We told them before we even filed the response that their motion to compel is moot, that all these issues have been addressed, and they continued to force us to file, schedule this hearing and whatnot. I agree that things could have been done more timely, but certainly the conduct of my client is not worthy of sanctions. It's certainly not worthy of civil contempt as they allege under Rule 65F. This court has already held that portions of its preliminary injunction order issued back in January are not so specific and definite that it would warrant sanctions or warrant a finding of civil contempt. Specifically as it relates to Section 3, that my client shall notify third-party vendors and take all reasonable steps. That's not an award that can be found in civil contempt of, because it's not specific and definite enough. That being said, my client has offered evidence that it has done that. And again, the plaintiff's frustration is with the third-party platforms themselves and their delay in changing the name on the back end. It's not with my client and its purported or alleged violation of the court's order. Thank you.
Okay, thank you, Mr. Glasser. Brief last word.
Thank you, Your Honor. On the third-party platform issue, just specific to the credit card processor, we learned the same time this court learned by getting the motion. Counsel never relayed it to us. I inquired repeatedly, what are you doing to address this credit card processor? I only learned what they did when I got this response. There's nothing outside of that, apart from the later discovery information that got recently. As to the timing of the payment, I noted one previous one, this was the TransUnion, that the court directed be paid by April 27th, that it wasn't paid till April 30th. We're not here for that. That's just context, Your Honor. We did file a notice to let the court know, and this was contemporaneous with that payment right after April 30th, but we filed a notice to let the court know that it was transmitted slightly late. That's not why we're here. On the transfer of the money issue, we're here because on April 14th, I provided counsel with hundreds of thousands of dollars. There was only about 20,000, 23,000 or so left in the account. I provided hundreds of thousands of dollars of invoices that defendants never once disputed, not once. They didn't pay it. I followed up again and again and again. They didn't pay it. Counsel just said, oh, we told them don't file this, it's moot. They transferred the money on June 16th. It was the night or 2 days before that their response to our motion was due. They finally transferred the funds. Your Honor, it's just they're not acting in good faith under the order, and they're forcing us to address this with a court. There's no indication they ever would have transferred the funds had we not raised this issue by motion with the court. They certainly haven't given any evidence of that. From April 14th, when we first provided the Experian invoices, until June 16th, there's no explanation for that over 2-month delay in that payment. And again, the payment went out because we filed the motion. There's no indication that they ever would have paid it without that. I rest on that, Your Honor. Happy to answer any questions.
I don't have any questions for you. I will take the motion under advisement. I'll issue a written ruling. Thank you all. Have a good day.
Thanks, Judge.
Judge.